we're going to discuss the subject professional responsibility. This subject is tested almost every single administration, so it is pretty much guaranteed that you will see a professional responsibility essay in July. In the past 12 years, we have only seen one administration of the bar exam where professional responsibility was not tested. When this subject was tested in February 2022, it was actually tested as a crossover question with evidence. So it seems more likely that the examiners will test this as a standalone subject this time, but be aware that we have seen it tested as a crossover question in back-to-back administrations before, so it isn't out of the question to see it tested as a crossover again in July. Although it's easy to predict that we will see a professional responsibility question, it is pretty tough to predict what issues the question could test. There are a few things that make these questions especially difficult. First, there's a lot of law to learn. The call of the question for PR essays almost always says to analyze potential ethical violations according to both the ABA model rules of professional conduct and the California rules. So you need to learn both sets of rules. There are quite a few distinctions between the model rules and the California rules, and every single PR essay seems to test at least one distinction. Second, there often isn't a right answer. The scenarios in PR essays don't necessarily fit neatly into the black letter law of the rules. So you should answer the question by discussing whether an attorney's conduct might be considered unethical under different rules. If you look at the sample student answers, you'll notice that they sometimes discuss totally different rules in their analysis of the exact same set of facts. So the more rules you know, the easier it will be for you to spot potential issues and make arguments that certain rules do or do not apply. The third thing that makes these questions tough are that there are a lot of different issues that could potentially be tested. Some of the highly tested issues on PR essays include fee agreements, conflicts of interest, specifically current client conflicts is their favorite, and the duty of confidentiality. With regard to fee agreements, there is a minor distinction to be aware of between the ABA model rules and the California rules. According to the ABA model rules, a lawyer may not charge a client an unreasonable fee. Under the California rules, a lawyer may not charge a fee that is unconscionably high. Even though this distinction might seem somewhat inconsequential, this is exactly the type of thing that you need to have memorized in order to maximize your points on a professional responsibility essay. There's also a distinction with regard to the rules for current client conflicts. Under both the ABA and the California rules, there are two types of current client conflicts. The first type is where the representation of one client will be directly adverse to another client. The second type is if there is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by a personal interest of the lawyer. Under the ABA rules, a lawyer can represent a client anyway, despite this conflict, if 4 requirements are met. The mnemonic to help you remember the requirements is RICI, R-I-C-I. First, the lawyer must reasonably believe that he will be able to provide competent and diligent representation to each affected client. Second, the representation is not prohibited by law. Third, the representation does not involve the assertion of a claim by one client against another client in the same litigation or proceeding. And fourth, each affected client gives informed consent confirmed in writing. If all 4 elements are met, the lawyer can represent a client even where there is a current client conflict. California also has an exception to the current client conflict rules that allows a lawyer to represent a client despite the conflict. Under California's rule, the attorney must obtain the client's informed written consent. That means that disclosure of the conflict and the client's consent to the conflict are both in writing. California notably does not explicitly require the R of RICI. That is, there's no requirement that the lawyer reasonably believe that he can provide competent, diligent representation to each affected client. There are also a number of scenarios in California that require disclosure of a potential conflict under California's rules, but which do not necessarily require the client's consent. For instance, if the lawyer knows that another lawyer at that lawyer's firm has a relationship with an opposing party or maybe a witness for the opposing party, the lawyer must disclose that fact to his client, but does not necessarily have to get his client's consent to continue the representation. Make sure you review the scenarios in which the California rules require disclosure of potential conflicts, as this is highly tested on the essays. The duty of confidentiality was a minor issue on the February 2022 professional responsibility question, but because it is a favorite topic, I would not be at all surprised to see it come up again in July. The duty of confidentiality prohibits a lawyer from revealing information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by one of the exceptions to the duty of confidentiality. Keep in mind that this rule applies to all information that the lawyer knows about the client that relates to the representation of the client, no matter what source that information comes from. So this does not just apply to communications between the lawyer and the client. This would include information the lawyer learns about the client from other sources as well. For instance, if the lawyer reviews the client's medical records or speaks with the client's family members and learns information relevant to the representation, all of that information would be covered by the lawyer's duty of confidentiality, and thus the lawyer cannot reveal that information. As I mentioned a couple minutes ago, it can be very hard to predict what might be tested on a California professional responsibility essay, since there is simply so much material that is eligible for testing in this subject. And also since the examiners are very creative and come up with very interesting new fact patterns every administration. The best way to prepare for this subject is to complete as many practice questions as you can in order to gain exposure to as many of the testable issues as possible. Since you are pretty much guaranteed to see a professional responsibility question in July, it's not a bad idea to spend a little extra time studying this subject to make sure that you know it really well.